It's a pleasure to have so many people here in the House of Finance, University's Western campus, for this lecture by this year's invited guest professor for financial history. It's Marc Flandreau, a colleague from the University of Pennsylvania and Wharton School, which is also a long-standing partner university of our faculty and the House of Finance. Let me briefly introduce Marc Flandreau, but before that, let's also welcome Kim Comperl, who represents the donors for this guest professorship in financial history, which is at the same time Metzler and the Friedrich Förderungsstiftung. And we are very grateful for the support for this initiative for already so many years, and there are still some years to come.
Yes, there's still some years to come. Exactly.
So, Marc, it's great to have you here, and you have already been busy in the House of Finance. I will surely tell about this as well. But let me first mention that Marc Flandreau is, as I mentioned, the professor of economic history at the University of Pennsylvania since 2017. And his academic career started in France. He is a French citizen, still French citizen, so
yes.
He will also have to vote in some weeks.
Yes.
Marc started his financial career at École Normale Supérieure at Sorbonne in Paris, then obtained his PhD from EHESS in Paris, and he became then a tenured faculty member at Sohn Co in Paris. From Paris, he went to Geneva in 2008 to become a professor at the Geneva Institute, and then changed to UPenn in Philadelphia. And it's interesting perhaps to also remark that between or before 2008, you also had an appointment as the chief economist France for Lehman Brothers. So you can speculate about the reasons that you left Lehman Brothers in 2008.
Well, it's a coincidence, but we can get there.
Yeah. Marc is a well-known expert in the history of finance, especially in the history of international monetary relations. He has written about, for example, and among many other things, about the international gold standard. And he has also research on financial crisis, regulation, sovereign debt, sovereign default, debt restructuring, and the geopolitics of finance. And well, he's written a couple of very, very prestigious and interesting books and a long list of articles in these fields. Let me just mention that when Marc has arrived here, he has already given a seminar in our master's program. Maybe I should mention that when the seminar was announced, it was selected by an incredibly large number of students, which was a little bit surprising also for us, but we managed then to restrict to a number of 30. And what I heard was that this went very successful. It dealt with the international monetary system, history and prospects, so one of Marc's focal areas. And besides the lecture today, Marc will also, or has also organized a conference dealing with the sovereign debt crisis in the world that they made in the 18th century up to the 20th century, and this will take place in 1 week. Next Thursday. So today we will hear about the law and economics of government platforms, lessons from the origins of the London Stock Exchange, also a very interesting topic. And before we hear this, I would also like to invite Kim Comperl for some words over that program. Thank you very much.
Professor Klump, thanks a lot. As you already mentioned, my name is Kim Comperl. I'm a board member at Bankhaus Metzler. Bankhaus Metzler is one of the two sponsors of this program. The other sponsor is the Flick Foundation. So first of all, very warm welcome to all of you. Some of the guests I actually know very well personally. So special welcome to you. You feel appreciated, hopefully. But I would like to, of course, also very welcome Professor Flandreau. We are very happy and glad you actually accepted our invitation to take on the visiting Professorship of Financial History. And we also would like to, probably in the name of in the name of everyone, thank a lot for all the works of Lotto Wegner, also with the team, who also make this happen. You know, every year we have somebody coming over and a lot of work. So thanks a lot for doing this. So I just wanted maybe to give you a bit of background why we have this program, how this actually existed, or why this exists. It's basically sort of a childbirth or child of the financial crisis in 2009, 2010. In the aftermath, I think Friedrich von Metzler, our owner of the bank, he got together with Baroness de Rothschild, and they said, you know, we both have a long history, banking history, and obviously there's some lessons to be learned out of the financial crisis. And they got together jointly with the Goethe University and thought, you know, what can we do? And came up with this program. And the purpose of this program, the thinking of this program was that without the clear understanding of history, there's no opportunity to understand the future, and it's a great building block from our perspective, from our bank, to build strategy going forward. And it's also important to understand history in order to react properly to crisis, which there have been some since the financial crisis in 2009, and I'm sure there will be more to come. With having said this, I would like to hand over to Professor Flandreau. The floor is yours. Thank you.
Okay. Okay. Thank you very much first for this for this invitation. It's a great honor, but it's also a lot of fun to be here. Last week, as Rainer was explaining, I was teaching this rather intense course with a lot of students who were very excited, actually, about the history of the international monetary system. And today I'm with you, so telling you about the London Stock Exchange. This is part of a research I've been working on for almost 10 years now, and which has many different aspects. I'll say a few words, I think, during the Q&A. But I'd like to dive in straight into the manner in which I would like to sort of pitch what this talk is going to be about. And it's very much a talk on one aspect of my research, which is the legal dimension of the organization of the London Stock Exchange. That's not a topic that has received lots of attention. Actually, I'll say in a minute that it's quite the opposite. The research appears to believe that there are no real formal legal origins to the London Stock Exchange. And the reason why I think it's an interesting topic to ponder today is the social networks. Okay, so today, and I won't spend a long time on that slide, but that's the way I want to motivate that discussion. Social networks are two things. They're markets and they're media simultaneously. So the digital platform that people are live these days are really straddling two dimensions, and they connect us to one another for social purposes. But they are also economic platform. They are trading platform. They are place where we exchange stuff. So I think that I don't need a long discussion to try and persuade you that this is a critical dimension of modern capitalism. My objective is to try and develop the idea that actually those platforms and their importance have a much bigger role in the history of the development of early capitalism than we have realized so far. Okay? And my focus will be on the London Stock Exchange. Here and there, we'll keep seeing emerging, in the narrative, other similar platforms that were created either as predecessor of the former London Stock Exchange, or as you will see, as other institutions that played a role at the same time. But the important element here again is the importance of formalized social networks and the role of law, in this case common law, in assisting the structuring of social relations at the cusp of modern capitalism. So the period I'm going to focus on, is very much the period of the Industrial Revolution. Okay, so that's the late 18th century. It just goes just a little bit into the 19th century, but not much. So that's really last quarter of the 19th century, 18th century story. What are the key messages? So the first key message, it's going to be a discussion of the importance of a specific instrument, which was voluntary association. So it's some kind of the English common law anticipation of the Verein, and which played an extremely important role at the cusp of economic modernity. And the reason why it was important is the sort of transitional function that it fulfilled. As we'll see, it was a manner to start and consolidate primitive, quote unquote, legal knowledge. So forms of legal knowledge that could be customary, or that could be formalized but come from different cultural traditions, and that were through voluntary association and through common law worked into a consistent framework. That's the first idea. The second is that because it was a creature of common law, the voluntary association was very well equipped to negotiate its survival with the legal system, and in particular to manage and acclimatize the regulatory shocks that could emerge as part of the development of new financial activities. Technically, a focus of the story I'm going to tell you is the problem of derivative trading, which was banned under English statute, but which got to be reinvented and reorganized and accepted ultimately by common law through the creator, that legal creator, which is voluntary association. And so what was really important there is that voluntary association also act as a form of collective action technology that enabled to negotiate the merger or the harmonization of the activities of certain communities with the broader polity and the law of the land. Okay, so that's the general idea. And to introduce what I'm going to tell you what you would read if you were looking at the existing literature on the creation of the modern London Stock Exchange. So I'm referring to classic works on the history of the London Stock Exchange, and they emphasize two dimensions. The first has to do with this gentleman over there, who's Barnard. So he was responsible for Lord Barnard was responsible for the creation, for the adoption of the Act of Barnard, which banned forward trading. That is technically what was banned, if you want to get a bit technical about that, was the shorting of the security, okay? So in other words, if you were doing a forward trade and the seller didn't own physically the security, then there was a ban. That's something that was not unusual in general in Europe in the history of security regulation, as I'm sure some of you know. The second aspect was the fact that the London Stock Exchange was formally under the authority of the Lord Mayor, so I'm discussing around 1750, and the Lord Mayor was regulating the stockbrokers, so he could grant individuals the right to become stockbroker. There was very light regulation, The important element was that the market, which at that time was a number of clusters, so mostly trading happened in coffee houses, and the main coffee house was Jonathan at that point. In 1772, they moved to a new building that's called the Stock Exchange Coffee House, and then eventually they will construct a new building in the early 19th century. The point that is established by a decision of 1762 is the open character of the market. So what happens at that point is that there's an attempt, and we don't have much traces of what happened, but there's an attempt by a number of stockbrokers to create some kind of club, but we don't know exactly how they do that and what are the grounds. And what they want is to use the coffee house to have the coffee house just for their own personal use. There's one of the stockbroker. He's a Huguenot who was actually he comes up in the record as a well-known person. His name is Reynou. He's not part of the clique for some reason. He goes over there, and the master of the coffee house punched him in the face, or something wrong happened, so they kick him out. And so he goes to court, and it's a Mansfield verdict, and a number of stockbrokers come and say, well, I mean, this is the market. And so the judge decides that if this is the market, it has to be open, and so you cannot shut it out. So this is the well-known part, and so then it goes to the interpretation that you find in the literature, that as a result of that, you had a problem developing, which was the lame duck. So in the conventional description of the lame duck, which is not the correct description of what they were, as I will show you in a minute, you have a lame duck that's over there. It's apparently a poster that was on the wall of Jonathan's coffee house. So that's a 1763 engraving, and you can see in the background the representation of the lame duck over there. But the argument is that, okay, since forward bargain were illegal, they couldn't be enforced. Okay, so you could always argue that there were no grounds to force you to pay those bargains. And indeed, there were no grounds to make you pay those bargains. Okay? So it was very easy to go to the stock exchange, make a forward trade, and if you win, great. And if you don't, well, you just don't pay, and that's it. Well, you'll see that, as I'm sure you already imagine, it was a little bit more complicated. But anyway, based on that, the literature has been emphasizing the risk of a tragedy of the commons. So the idea is that anyone could come to the market and do whatever they wanted. The market was open, and so there was no way to get rid of the lame ducks. So people would just come inside the market, and they would do whatever they please, and they would never honor their bargain. You even wonder how they had a market, as a matter of fact, if that story was true. And so there would have been a disaster in the making, but for many, many years, right? So finally, in 1801, there would have been a solution emerging, which would have been an enclosure of the market, okay? So the story continues saying, well, the modern stock exchange is born in 1801 as a private order, and so what they need is a way to keep those lame ducks at bay. They want to have them out of the market, so for that they need an exclusive organization. And so what they're going to create is an informal organization. So they decide who's going to be part of it. Those who are not part of it because they're not morally, something, they get kicked out. So as a result, they would have developed a kind of parallel legal system, but more like of a mafia type, right? I mean, they make their own rules. So it's kind of, gentlemen in top hats who make their rules as they damn please. And you have that view very widespread in the literature. So the two great historians of British Empire, Keynes and E.G. Hopkins, they have in their classic book a discussion. In fact, they discuss the British Empire, but not so much the London Stock Exchange, which is weird. And they describe the rules of the London Stock Exchange as being mere gentlemanly codes of behavior whose prestige rested on the informality of its proceedings, the proceeding of the market. Okay? So now I've told you all that, and somehow I'm going to ask you to forget about it. And I'm going to offer you a very different story of what happened. So the starting point is the importance of the common law company and the difficulty that historians have in order to identify common law companies and sort of know what they were doing in the early modern era. So classic corporation under English law, okay, could only be created through a parliamentary or a royal authorization. So they needed to be chartered, okay? So that's the typical case is the East India Company that you all know of. So you need to have like the sovereign giving you that authorization. However, and even if there were questions about, what was the legality of that, developed very early on a different approach to incorporation, which is the creation of what is known as unincorporated companies. So these are companies that are going to be created by contract, okay? So partnerships are a good example of that. And in particular, what played historically a very important role was the trust. Because you could create any kind of partnership and then you would put the assets in the trust and then you could write pretty much anything you wanted in terms of how the trust would manage the collective wealth. And here it is, you have basically recreated as a derivative product a sort of quasi-bona fide corporation. Okay. Now, there's a long debate still raging on, the merits of this alternative form and when eventually the Companies Act was adopted in Britain in 1844. Does it really add something and so on and so forth? And I'm not going to take you there because that's a bit in the conclusion, but that's not really relevant here. What I'm interested in is the specific sub-case of a common law company, which was the voluntary association. Okay, and I think that the voluntary association deserves specific interest and is an extremely, so that's my governed platforms, if you will. They play a very important role in the descent of modern capitalism. And the case of the London Stock Exchange can be used as a guide, although it was hardly the only one. There were literally myriads of them. The first author to emphasize that was a British legal historian, Friedrich Maitland. If there are legal historians in the room, I'm sure you know everything about Friedrich Maitland. And he did that in an Austrian journal for the first time. In 1904, he develops the argument that, well, you people are all admiring the German corporation and German corporate law and so on and so forth, but us, Brits, we've invented everything long before, before you came up with this avatar, because technically, with common law, you can recreate any of the modern German corporations. So then he goes through the various forms of incorporation, and he says, okay, so you have this one. So for instance, he reached the point of the Verein, and he says, actually, what we have is voluntary association, and for instance, the London Stock Exchange. So by the way, there's something that is interesting, which is that the fact that the London Stock Exchange was a formal common law creature, not just the whims of a bunch of gentlemen, is something that used to be known by a prominent legal historian, although in business history it got eventually forgotten. Now, how does voluntary association function? And it can be many things, because you had voluntary association which were about in the 18th century, which were part of kind of the coffee house movement. So you would have dining voluntary association. You could pick pretty much any. They're social groupings, so you can do pretty much anything of what you want. So the members are defining an objective. Can be social, it can be political, it can be economic. During the 1790s, you have a lot of radical organization that oppose the government and that use the voluntary association instrument to organize themselves. The important element to understand is that those voluntary associations are contracts. They are contracts. Technically, they are contracts of every member with every other member, right? Obviously, that's a very difficult contract to write down. So the trick, so to speak, is to make bylaws, right? And then ask individual members to join, and if they assent to the bylaws, then they're in contract with everybody else. Okay, so that's the manner it's done. in order to represent the collective, to have personality, in order to represent this kind of collective, and at some level, even if it's legally and contractually constructed, amorphous from an economic point of view grouping, they appoint a committee. And the important element is that the committee has a jurisdiction over the members. And you can write down pretty much whatever you want in terms of what are the rights of the committee over the members, okay? So it's a very flexible, very flexible instrument. So, and that's a very important part. So some associations are kind of minimalist, so they give very tiny authority to the committee. So you can have, let's say, a wine drinking group, and the committee is just picking, you know, the time when the drinking takes place, and collecting the fees and paying the innkeeper for the expenditure. Or they can do a lot of things and have enormous power if you just say so. They have bylaws. In the case of the London Stock Exchange, ultimately, when the bylaws start being really refined and very long, they eventually have a clause that says, oh, and in no case can the committee be bound by the bylaws. So it's even, you know, you can decide that even if you're, you know, if you have a contract that extremely specific for a number of actions, the governing committee can take on itself, just push that aside and take the decision that they want, because they represent the collective interest and the collective will, okay? Now, the manner in which this operates is a kind of algorithm. So you typically have a provisional committee, who are the leader of the operation. They appoint members. The members then become kind of provisional members, and then they elect a bona fide committee. And then next year, the bona fide committee, again, appoints the members, so that's a way to clear those who have not, you know, behaved properly or anything like that, okay? Then after that, the elected members vote for the committee. And typically, I mean, different organizations have different mode of functioning, but the one I described is kind of the default. Now, the committees enforce the bylaws under penalty of exclusion. That's a very important element, okay? So in other words, you don't behave the way the committee tells you, you're out. And the courts enforce the exclusionary power of the committee because the bylaws are contract. Okay, so it's the right of the collective to get rid of an individual who doesn't go by the contractual clause. So that's. And so you have a whole succession of decisions that admit that logic. Now, this is a powerful system because it's a form of legal devolution. Huh? Why? Well, because technically, and that's something that Maitland was emphasizing, and I think he's the only one to have really seriously emphasized that. When you look at the vocabulary that is being used to describe what the committees are, they're described as tribunals. They are courts, right? And when they take a decision, it's in a sort of court-like framework. So, you know, there's going to be a plaintiff, and there's going to be a defendant, and there are going to be witnesses, and eventually the judges in the committee will return a decision, a verdict. And so, in fact, what is happening there is a form of legal devolution. If under common law you can organize platforms like that make their rules and enforce their rules, that means that under common law you have the possibility to create kind of insisted groupings that function according to their own rules. Important point, this is not informal at all. Again, that's very formal, and it's a study of what lawyers do. Now, the reason why I think it's going to be very powerful is that, and that can also lead to misinterpretation, is that in order to negotiate the border between those creators and the common law, you need to minimize clashes, right? If suddenly there's a clash and someone goes to a court because there's a dispute on this and that, then you will have to go to the judge, start, you know, putting all your bylaws out, and it's really something that you don't want to get so much, you know, out there. And so what these organizations tend to do is that they rely on incentives, right? They try to persuade by designing incentives, right, that almost give the impression that these are self-enforced bodies, right? And so this is why one can very much mistake a voluntary association for a private order, okay? Because somehow it's designed in a manner that emphasizes incentive compatibility as opposed to coercion. But to repeat, the really important part is that in the background of that, you have the role of courts, because the court ultimately enforces the bylaw. So there is a very important legal dimension there, okay? Now that I've told you that, I propose a way to rethink why the stock exchange ended up developing in 1801. Why in 1801, right? The Barnard Act is 1734, so there were like at least 3 generations of stockbrokers who went through the market until they finally figure that they have a lame duck problem. So it's because they don't have a lame duck problem as such. So let me develop a little bit. So the Barnard Act is not so much, as I'm going to show, something that creates problem in terms of moral hazard, right? And the lame ducks, in fact, are not bad people as such. They're just bankrupt. And the problem is that, yes, as a result is that what you have here is a distress problem. Why? Well, you see, this is, for instance, the sort of announcement that you find in the media. The media was following very much what was happening in the stock exchange, and that each settlement, they were initially quarterly, and then they moved to about monthly settlements. You have a number of people who fail, and so you find this strange formula. No less than 25 lame ducks waddled out of the stock exchange yesterday, right? Now, why do you have a lame duck as opposed to a bankrupt? Because you cannot use the traditional tool that exists at the time under English law to deal with distress, okay? Why? Because, well, a stockbroker has in his books tons of derivative contracts which are illegal under the Act of Barnard. So there's no way they can be enforced or settled or discharged in a court of bankruptcy. What the court of bankruptcy will do is say, oh, first to begin with, those contracts don't exist, okay? So you don't want to go to a jurisdiction that's going to disallow 70% of your balance sheet, right? That's not really going to help. But it goes further than that, because under English common law, you had alternatives to being discharged by courts. And you had in particular a private instrument which relied on putting the assets of the bankrupt in a trust. And then the trust would administer the asset for the creditors, okay? And that was a technique that was often used among sophisticated operators, especially financial operator, banks, etc., as a very powerful tool to deal with distress. Except that, what are you going to put in the trust? The proceeds of debts that initially had been created by illegal contracts. So that means that the whole instrument is void, right? So the trust is not a feasible instrument because it would rest on void instrument. And the same applies to collateral. Okay, you could possibly just post collateral, right? But courts waver a little bit, and then pretty rapidly they come up with the view that, well, technically that's an evasion of the act, right? So if you collateralize what was not enforceable, sure, you're smart, but I'm not going to help you enforce that contract. So there are some traces that collateral was posted, but it was more like an instrument that was used against outsiders, so people who didn't know much about the law of the stock exchange. So for instance, a client, right? So you would have the client post collateral, and then you would, cash out the collateral, and the client would have to sue. And of course, if they have the right advice, they can get back their collateral, but maybe they don't have the right advice, or maybe they don't want to be seen in court, right? And bear some kind of reputational risk. So what they're going to be doing, and that's kind of the end of the story where now we are going to be heading, is that the stock exchange, in order to deal with that, is going to basically sort of put the bankruptcy problem on its head. So what is bankruptcy law? Bankruptcy law can be interpreted as an instrument that enable an accidental partnership, okay? I didn't want to create a partnership with these people, I was just lending to them, right? But, okay, there's distress. So then you have instruments that encourage cooperation between those various parties that have no reason to cooperate with one another. And that instrument operates ex post, that is after distress starts. There's another way to approach that, which is to create the partnership ex ante, right? So the trick that they're going to use is to create essentially some kind of joint liability lending system, okay? So it's not unlike what you have in developing economies today, where you have a credit cooperative that are being created that rest on joint liability. So the idea is that, you know, you lend to one individual, so some kind of tontine, I'm sure you've heard of. You lend to one individual, but the individual is part of a community. So if the individual cannot pay back the debt, what's going to happen is that the community is going to step in and deal with the distress in this manner, okay? So that's exactly the same idea. The LSE will create essentially a debt restructuring community. So the association of stockbrokers will create itself as an insurance corporation, so to speak. And in this manner, they'll be able to manage distress in a much more effective way. And the instrument that is going to enable them to do that is the voluntary association. Now, this didn't come overnight. And so one part of the story on which I could give the entire lecture just on that part, because that is a fascinating part of the story, is that before they create the voluntary association, which of course is a complicated creature, because what are they going to do in this voluntary association? Well, activities that are not legal, right? So it's unclear you can go straight there. So they don't. And what they do instead is they go by stages. The first stage that emerges in the 1760s, and that you can reconstruct by culling up fragments from the record, is what I call the stock exchange bankruptcy ritual. So in other words, there's a codified approach to failing. First, the settlement day, names are called, you have to come up and pay the broker might ask you whether you close the position or you renew the position. And if you want to renew the position, you might have to settle the losses that you did before. So that's not collateral, right? You're just paying for that. And maybe you cannot pay your losses, okay? So at that point, and the ritual seems to have evolved over time, so your name is called out. There are stories of a sort of clerk that climbs on there's a sort of ladder, and he knocks on the wall, and he makes awful noises, etc. And then you have to perform the walk of shame, right? So the bulls and the bears, as they are referred to in the market, are like howling, you know, and making all this racket and kind of celebrating default in the strange way. And meanwhile, the defaulter is walking out. So this is an engraving of that time, and you see a number of individuals, these three, who are walking out of the market. And I've zoomed that for you. You see that they have webbed feet. So in fact, they are lame ducks, right? You see there. So this guy, I mean, you can't probably not see it, but here, this one is a little clearer, and you see this one. So this is when you become a lame duck, all right? And so you have to walk out, but that's not the end of it. Because of course, that's just the beginning of the bankruptcy. So the next stage is you have to meet with your creditors and open your books, right? That's the second moment. And start negotiating the discharge. Your creditors see your books. Of course, you could run out of town. I mean, you can do that too. But they see your books and they learn about, you know, what has happened to you and how you failed, what was your position. And in fact, if it's, you know, a stroke of fortune or things like that, this is the 1790s, is during the time during which, you know, Napoleon is ransacking Europe with his troops. And so the fate of bond prices can be toppled in just, you know, three weeks. And so suddenly the market can revert. And one reason why a market maker, for instance, falls might be just because there's a new political event that they had not discounted. And so in this case, that's absolutely not their fault. They should be discharged. So once they have the book, they can calculate the ability to repay. Are you a narrow stock brokerage, or are you a big firm, etc., etc.? What's your turnover? And so based on that, what they do is that they give you debt rollovers, write-offs, they discharge you, and they return you to the stock exchange. Sometimes, because there seems to be a chronic a lack of liquidity in the market. So that's the standard manner in which liquidity shocks are being dealt with. Sometimes it just takes 2 days, 3 days, okay, for a defaulter to settle with his creditors and get back in the market. Now, okay, that's pure goodwill and purely voluntary. So you have a number of techniques that emerge and that enable people to make that work. One, that's the most famous one, but it was not, in fact, the most important one by far, but I start there, was the blackboard. Okay, so they do that in 1787. In 1787, in July, there's a crisis, again caused by political events, and what you have is that you have a contagion phenomenon. So at the crest of the process, 50 stockbrokers are failing. And as a matter of fact, what is happening is that some stockbrokers announce that they are not paying because, of course, what is happening is that the debts are chained. So at some point, you realize that you're going to be the first somehow sucker who's going to pay for the others. So the trick and the response for everyone is to say, oh, I'm not paying, right? Of course, that's not really helpful. And so what is helpful is to cooperate and to have transparent a transparent attitude. So what they do at that point is that they resolve that all those brokers who do not account for their deficiencies, okay, or give up their principal, so the principal are the client, and so some people were making the excuse that, oh, I have this client who won't pay, right? So that's why I can't pay you. Huh? Okay, show me your books. Oh, I don't want to show you my books, okay? So you do that, you get your name on the blackboard, right? So transparency becomes really one of the rules of the market. Again, it's a soft enforcement technology. Another one is buffeting. Okay, so buffeting is a fascinating story, and same story. We could have much more. We could take much more time about that. So when you look at the description accounts by journals of the operation of the London Stock Exchange, you have a description of episodes of some kind of charivari where there is a person who tried to enter the market and was brutalized. Okay. What are those persons who do that? Well, they are typically, in fact, lame ducks who have not settled. So they are lame ducks who have waddled out, but they refuse to meet with creditors, they refuse to negotiate a discharge, and they just try to force their way back. Okay? If you do that, contrary to the legend that the market was an open market, you're going to be very much abused. So what happens is that the other term for buffeting is topping off the hats. So the technique consists in attacking you with your hat. So either they take your hat from the back, someone comes from your back, puts your hat over your eyes so you're blinded, or they send your hat flying so that you have to run after that. And that's just the beginning of the abuse. Then you get, then you get all the clerks. So they're not exactly clerks, that's, I'll tell you in a minute why I use this image, because of course I don't have an engraving of exactly what was happening. But the clerks, if the court, remember there was the case of the expulsion of a stockbroker. So the technique is that you need to make sure that no one can be assigned, a charge in court. So you say, oh, that was a joke. Huh? So the kids do the first attack, and then the adults join in, and there are stories of broken limbs and things like that. So it's extremely brutal and violent, right? And I could sort of go on telling you the stories that. What is very interesting in terms of kind of the cultural concept that's in the background is that the manner in which they treat the lame duck is basically the manner in which, for those of you who are familiar with Guy Fawkes and the Guy Fawkes celebration on November 5th, that still take place in England, they have a dummy of Guy Fawkes and they put fireworks and so on and so forth. They do exactly the same thing. So the transgressor gets his pocket filled with firecrackers, they lit up the firecrackers and so on and so forth. And I think it's very interesting that there is this kind of transpose, because as you all know, today Guy Fawkes is identified as the anti-capitalist figure, right? And so it's kind of interesting to see that it's the target of the people who defend the integrity of the stock exchange. There would be a lot to say about that. Or they use technologies that come from the sub-communities that compose the London Stock Exchange. So in this case, for instance, one thing that they use, and which is one of the first things that they will put into their rudimentary formal bankruptcy law when it consolidates in 1798, is something that is known as the Rabbi Nathan's lien. And the trick is the following. The idea is that if A is indebted to B, okay, and B is indebted to C, right, and B goes bankrupt, C, right, can collect from A, okay? So in other words, the technique reduces the obstruction power of the uncooperative defaulter because the community considers, okay, that the debtors of the uncooperative individual are actually the debtors of the creditor of the uncooperative individual, okay? And if things more or less balance out, there's even a way where, you know, you have to be cooperative. It's the dominant strategy, okay? And so the idea that's here in the background is one of transmissibility of debts, given the importance of the number of Jewish traders that operate in the London Stock Exchange. It's pretty clear that although there are like rational reasons for adopting a technology like that, this was also a tool that was absolutely natural for some of the operators. Okay. Now, finally, and this is where voluntary association enters the first for the first time, reputation. So I told you a word about the blackboard, but in fact the blackboard was more like a bogeyman. Because technically the blackboard is not privileged. The blackboard is subject to libel law, okay? So because if you expose the name of someone under English law of slander of those years, you're presumed committing a legal fault, and you can be sued for doing that, okay? And in particular, what is happening in a case like that is that the standard of evidence that the author of the libel has to submit to is very high. So the proof of the words is not enough, so you need to be able to prove that there were grounds, but that's not enough. You also need to be able to prove that there was no malice. So if you say something that's true about someone, but the reason was to harm the interest of that person, you're still on the hook under the law of slander. So as a result, people needed another technique, and this is where sorry, I wrote trade protection properties. It's trade protection societies. That's the reason why trade protection societies, which were voluntary associations, start appearing in the late 18th century, okay? So this is one example. So that was kind of the prototype. It was called the Guardian, Society for the Protection against Swindler and of Property against Swindler and Sharpers, right? And the idea of those organizations is that they're voluntary association, they have a committee, I told you all that already, okay? And the powerful element is that they are private contract, and as a result, they enable the private circulation of information. So if I'm a subscriber of a trade protection society, I can go to the secretary and say, oh, there is this person who wants to become my client. Do you have anything on that person? And the secretary will give me this information confidentially, and this will be absolutely privileged. Okay? So as a result of that possibility under common law to get organized and escape the danger of slander, etc., you have this kind of expansion of the number of organizations like that. Not surprisingly, the stock exchange develops its own. Okay? There are very limited fragments that show its existence. It was called the Society for the Protection of Property Against Fraud in the Stock Exchange. We don't know actually exactly when it's created. I suspect, for a number of reasons, that was in the 1790s, but it could be earlier. And what they do is that they write reports on individual stockbrokers and on clients. So that's much more powerful than the blackboard, right? Because what is happening is that any behavior, okay, any behavior, so including suppose that you are an aggressive creditor, okay? You can be, and you know, you've made an arrangement with a defaulter, and the defaulter has to pay you, and a certain installment, and suddenly you need the money and you start bullying the individual, maybe because in terms of trading, he has to rely on you or something, so you need some tool to coerce the person, okay? That person could possibly go to the Society for the Protection of Property and say, hey, this guy is really after his money, right? I mean, this is not helpful for all of us, right? Okay? So that's the first level of creation of a formal organization, and this formal organization become very rapidly extremely powerful and will help graduate to the next stage. Nonetheless, there are many limits to this kind of private failures. It's kind of this customary instrument that they are being used, and you don't need to, I mean, that's much, I suppose, this point doesn't need much explanation. There's no centralized decision making. It's always a defaulter with a group of creditors, and they have to go to the coffee house and haggle and, whatever, come to terms with something. It's not easy. There's no accumulation of precedent. So of course there's some kind of precedent, but again, all those clusters are different. So you know what was used in that failure in which you were involved, and if you like the way it was done, you may in the next failure say, oh, we did it that way, we should do it that way. But if the others don't agree with you, there's no way you can stabilize a sophisticated bankruptcy instrument. Stockbrokers are individually, so the senior stockbrokers are often, they're traces that they often approach and say, can you give us guidance so that we can coordinate? But they feel that if they do that, they're going to alienate people, so they don't want that. And so against that, you have a lot of untransparent discharges. It's very easy to find ways actually to squeeze out some creditors by just arranging like fake trades with, senior creditors and so on and so forth. And as I was saying, there's the problem of exploitive creditors. Maybe the Society for the Protection of Property can do something like that, but it's really unclear. Okay? So the turning point, and we're getting almost there, the turning point in 1798. What they decide to do, and technically it's the Society for the Protection of Property that does that, its leaders have this idea, this grand idea in late 1798, we're going to create a jurisdiction, okay? So that jurisdiction has no legal status. It's just there, right? And what is important is that it is centralized, as opposed to all this clustered of negotiation that were taking place. Suddenly you have a venue where you can go, and in principle, they have established, but it's very difficult, to fully enforce without a bona fide voluntary association, to persuade that everybody has to subject to their bankruptcy process. And what is their bankruptcy process? Oh, they don't innovate much. They just use the previous customary instrument, okay? Except that now there's one court of justice, there's the committee that is dispensing that justice, okay? But it's not, they're not really innovating anything. So what does that mean? Well, when a defaulter is reported, the committee appoints a committee of inspection. The committee of inspection goes and opens the books. If they find that the defaulter is an honest individual, they have to treat that person with tenderness and humanity, because poor people fail every day, we know that, right? And then that person will be reintegrated in the market and the losses shared. What is important here is that, again, everybody, as long as they cooperate and they are transparent, have an absolute right to being discharged, right? So you don't have you don't have liability beyond what you can pay and what are your assets, right? The last point, which I think is probably the most important one, is that in addition to all that, they impose that they are going to be equitable distribution. So what does that mean? That means that a defaulter who's being pushed by some creditors to give them preferential treatment, or a junior creditor who was shut out or disfavored in the discharge that was negotiated can go to the court and say, this is what they did. And they have a clawback right, that is, the court will instruct the money to be restituted and paid back. Of course, again, this is purely on reputation, but think of it like this tribunal is a spin-off of a voluntary society that keeps tabs on you. So obviously an individual who is difficult, who doesn't accept to do that, they have a very clear way now to know whether that person should be reported or not in the common book. All right? So now they're almost there, but again, there's a sort of risk. What are the courts of justice going to do with a strange voluntary association that is there to discharge debts which ultimately are not legal, right? So the courts are going to come to the rescue of the stock exchange. And the case is Morris versus Langdale. So Morris was a defaulter in 1800. You see, I mean, it's very fragmentary, but you see a trace of that event in the books of the stock exchange. And from what we understand, the normal process was applied to him. So what happens is that his debtors, for instance, in particular, are paying over their debts to him, to the creditor of this uncooperative Morris. Okay? So he's just subjected to the instrument. Now, he has an idea with his lawyer that, well, they could actually find some ground to sue. How are they going to do that? Well, the idea is going to use the law of libel and slander, right? And how is it going to work precisely? Well, Langdale, who's going to be the defendant in this case, has been heard telling a witness that they can produce to the court, Morris, he's a lame duck. He's gone and he will not come here again, because that's an uncooperative one. So the guy had come to the market and was trying to meet with him, and is being told, no way you find this gentleman. Now, what happens? So there's a trick here, okay? There's a trick because the evidence is going to be complicated to bring. So the lawyer, the counsel for Langdale, tries the first defense saying, well, you know, it's a stock exchange, so, you know, like in terms of producing the evidence, we cannot really do that. And so it's sort of going nowhere, because the whole idea is that they're sort of taking the defendant in a corner, right? Because, sorry, they're taking the defendant in a corner. Why? Because either the libel is recognized, okay? And in this case, there is a charge that can be computed, because what has the plaintiff lost? The plaintiff says, oh, there were all those contracts that were owed to me, on which I would have made money, and they were cancelled. So that is the amount of prejudice that have been that I've suffered because of the libel. So as a result, what I'm asking from the defendant is that they pay me back for those losses that I've suffered. And of course, if the court is siding with the plaintiff's request, then the instrument is toast, right? But the judge comes up with you have to read it twice, comes up with an answer that actually gets sorts out the situation to the advantage of the stock exchange. He says, no special damage can be said to have arisen from words which may import an accusation that the plaintiff has not done that which the law prohibits, okay? And so what does that mean? Well, it means essentially, well, you go to the stock exchange, and you play there, things are going to happen to you, okay? And you cannot then come back and act as if you were in the normal economy, right? And say, there is slander, therefore I have a right to collect on the person who has slandered me, okay? So in other words, what he recognized is that the stock exchange is a specific space, ruled by specific principles, and as a result, he recognized, in fact, the nature of the social network. A few weeks later, after the case is decided, the stock exchange receives legal advice that they can turn themselves into a voluntary association, right? And the formula that they're going to use is that they become the subscription room. Okay, so it's not the social network, it's the subscription room. It's a very vague expression, but in fact it's not a very vague expression, and everything is in the name. Why is it so? Because speaking of a subscription room fixes the whole problem. The difficulty that that organization has is with the production of bylaws. How detailed are they going to be? Are they going to explain that, well, they do this contract that are not necessarily legal, and there is this and there is that. So all those activities are somehow in derivative product, or somehow standing against the law of the land, right? They cannot do that. So what they're going to do is to have minimalist. They're going to have minimalist interpretation. The judge said the stock exchange is a specific space. And they interpret it as, okay, we have jurisdiction over that place. So we don't need to explain what is in the bylaws. Later, they will elaborate on the bylaws. The only thing that they need to do is to say, well, what we do when we go to the stock exchange is that we submit to the committee, right? So in other words, what it means is that the committee has full power for whatever reasons they want to get rid of us. So this is a form of dictatorial power somehow that they give to the committee. But what is great about it from the vantage point of the stock exchange is that this enables them not to get into all the complication that would have been involved if they had to describe all the reason that will lead the stock exchange committee to get rid of someone. Okay? So I'm going to stop here the kind of the legal story, and I would like to conclude on a few points which I think are really important. So the first idea is that early capitalism was somehow an immense accumulation of organized networks. The city of London, I have that somewhere. The city of London doesn't have just the stock exchange. The Lloyd's is a voluntary association, same instrument. The London Clearing House is a voluntary association. A lot of mercantile insurance organizations are built as... So the number of important financial institutions that are being created that use that instrument, the social instrument, is just staggering, okay? Now, these networks, despite the impression that we have that they are amorphous, are not at all amorphous, they are governed, okay? The problem, of course, is an observation problem. It's a problem of optics. So think, for instance, of the case of the London Stock Exchange. In order to negotiate the problem of the conflict with the law, they don't specify their bylaws, and they give full power to the committee, okay? Now, it'd be, okay, this is a very autocratic organization. Well, no, because the part of the bylaw that then they make public and they communicate are bylaws that explain exactly how the committee members are appointed. And that process has to be ultra-democratic, okay? Right? So what they're trying to have is that, okay, we're going to have a dictator, because that's the way in which we can negotiate the tension with the law of the land, but then this dictator is elected every year, right? So we can get rid of the dictator if they use their power for their own system. Now, when you look at it from the outside, you're going to have the impression, oh, this is so informal. But no, because they have all those rules. Sometimes they write them and they post them, but they don't print them, so you cannot really, you know, they don't have this public existence. But they have all those rules according to which the behavior of the judges are being assessed. So in fact, it's informal, gives the idea that people can do whatever they want. No. When you look at the archive, you realize that through that instrument, they can do they must do extremely precise things, and their powerful expectations on that, okay? So that takes me to this point I've made, to the fact that the importance of the voluntary association as a poorly understood form of common law company that should be studied per se. And every single voluntary association is going to be a bit different. So you have similarities and differences. I've started looking, for instance, at the Lloyd's. So when the Lloyd's creates its first space, they call it the subscription room. It's exactly the same technology. But then, of course, the Lloyd's faces different sets of problems. They don't do the same thing as the stock exchange. So they also can develop their own type of law. The next thing is that as a result of this, these are strange organizations. They're kind of capitalism without capital. Huh? Why is it so? Well, because if you think of kind of mentally of a sort of aggregate balance sheet of the association, it takes care of default by operating redistribution, okay? It doesn't need, strictly speaking, a capital to do that, right? It doesn't. Because what it does is that it writes down liabilities on members. And it is possible that some members at some point shun their liabilities, in which case you will have to redistribute this liability and again balance that inside the association, okay? That doesn't mean that it cannot connect to traditional capital. So for instance, the stock brokerage, all of them, they are little partnerships. 2%, 3% maximum, right? And so they have a capital, and that capital is also what people look at when they restructure a defaulter, okay? So when they look at a defaulter, they're going to look at all the illegal operation, they're going to look at the capital that the small partnership has, and they're going to restructure it in this fashion, okay? But this is some kind of like, you know, it's off the balance sheet of the association. So one way to think of that is that these are pure goodwill organizations. And indeed, what is the collateral against which the debts are restructured? It's the future income from trading. As an organization, the stock exchange knows that it's generating a certain cash flow from basically brokerage charges. So the total volume of the cash flow is somehow the collective earning power, right? And so the only thing that you need to do is to find a way to incorporate that, and inside that structure to allocate losses when they come in a manner that keeps the system working. A very important element of that, which ties to prudential regulation, is that under a system like that, you have absolutely no incentive to organize a squeeze, right? Why? Because if you organize a squeeze in a market like that, well, the people you've squeezed, you have to discharge them later, right? So in fact, it creates a form of cooperation inside the market, which makes the management of financial distress more effective and forces somehow the trader to internalize the cost of distress, okay? Now, I want to end on a note about the kind of the long-run evolution of this creature. So, I think it plays a very important and unacknowledged role in the late 18th century, early 19th century. So, voluntary association should be looked at, and because at that point, it is, as I said, it is political, it is social, it is economic, right? Over the 19th century, there's going to be a separation and between various forms of voluntary association. So they're going to be the clubs. The clubs are clubs, you know, they're purely social. And they're going to be the actual businesses, right? And a time will come where it will be impossible, in fact, to structure any voluntary association of that kind if it has profit as an objective, right? And that's why the insurance setup was kind of straddling a sort of gray zone, because it's not strictly speaking profit. Insurance is about redistribution of risk, right? Okay, so there's a collective benefit, but it's not the same. And so when you look at the decision, the legal decision during the 19th century, what you see is a very strong effort to start separating inside the social network what is the economic concern and what is the social concern. And when you reach the late 19th century, kind of the whole set of ideas that enable to use a social instrument to organize an important economic activity was basically gone. Okay, thank you very much.
Thank you very much for this inspiring talk. I think we have time for some questions.
Of course.
And would you like to go first? Yeah.
Super interesting. Thanks a lot. Absolutely fascinating. Maybe it was in passing, or it was just me not paying full attention. You had something to say about limited liability. That this came out of it from the discharging element, right? Mm-hmm. I understood you that you couldn't fully punish the people because you had to readmit them to be part of the association future on. Is that the limited liability that we have nowadays? Because in econ theory, right, so the way we think about limited liability is well, you know, in order to amass the size of capital that you need for a corporation, you cannot possibly have this as a punishment, just a scale argument. So is that linked? I mean, how does that fit in?
Yeah, so it's a very good question. It's a very different animal. So first of all, I've made a parallel with joint liability lending organization. And so in the joint liability lending setup, what you have is that the other member of the association are liable of your losses. Okay, and so that's tied to concept of limited liability. In other words, you cannot give more than what you what you have. And the other thing that I think is very relevant for that story is that joint liability lending typically occurs in contexts where collateral is scarce. Okay, so in fact here you have, because of legal reason, something similar, because collateral was scarce because you couldn't pledge collateral, right? It was not strictly speaking scarce. Huh? So once you have that, you have to completely reinvent the concept. So it's not that back then they didn't have an understanding of limited liability, or rather, as was more like the norm, unlimited liability. So for instance, the little partnerships that were in the back of those organizations, they had technically unlimited liability. Okay, but maybe they had very small capital in them, right? Just a couple of £1,000 that was not a huge amount of money. So if you had a loss that was bigger than that, so then the point is that the association gives you a completely different approach to the concept of limited liability. So in other words, what you have is a concept of ability to pay. That's why they want you to show your books. And then the ability to pay and the level to which the judges decide you're a victim or not, define what is going to be your liability. Okay. Bear in mind that because of the nature of the setup, which is intertemporal, it exists for many years, you can pay in future income, right? So in other words, when you do this discharges, maybe what you get is that typically you sit with your creditors and you say, listen, right now I cannot raise the money, but actually I'm completely fine. We agree on a plan for installment. In the next 4 quarters, I'll pay you the amount that is being due. You need to agree on the discount rate, and that's it. Okay. So in other words, what I'm trying to say here is that that machinery created a very original. We have literally to rethink our traditional categories, right, to understand the manner in which they operationalize that. But again, it's not because they don't understand limited or unlimited liability. It's really because the setup in which they reinvent that concept of failure, okay, is such a different one than the one we're used to.
Yes, thank you very much. My 2 questions are about the enforcement technologies. So my first question is, were they introduced by the committee, or were it practices that developed in a way bottom up and later on were institutionalized in a way? And the second question would be a comparison with other stock exchanges. So, of course, in Paris and in Berlin it's later and it's under legal different conditions, but did similar technologies, enforcement technologies, exist there too? Okay.
First of all, when you were mentioning enforcement technologies, you were referring to this part of the talk. Okay, so initially these enforcement technologies are, I call them the law of the people. Okay, it's the law of bankruptcy of the people. So they're just completely bottom up, and that's why also there is this kind of joyous, childlike, celebratory, thing, right? Where when the stock exchange committee comes over and gets involved, I wonder if I have kept it there. No, I didn't. Okay, when the stock exchange committee is created and the association is created, the first thing that they do is that they outlaw those bottom-up, those grassroots enforcement technologies. and for a very good reason, because now they are the law, okay? And so when the stockbrokers enter the room, after the room is transformed, it's the same room, right? But it's called, now it's the subscription room, so they exit and then they come back. So in the new subscription room, there are posters, and they're being told that anyone who will engage in abusive behavior as before is liable to a fine, and if they don't pay the fine, they can be fired, okay? They can be expelled from the market. So what the committee is doing at that point is asserting its authority as the tribunal. And that's the difference with the situation. Remember, the tribunal is created in 1798, but it doesn't have the power to coerce individuals, right? So they need a voluntary association, because then the committee has the power to expel. So at that point, they don't have it. It's just indicative. And there's the threat, because the Society for the Protection of Property is keeping tabs and might put your name in the wrong list, so you don't want that. But that's all, okay? What is happening with 1801 is that actually, I had it, crackdown on buffeting. So there's a fine on any subscriber guilty of any such disorderly conduct as formerly in the stock exchange, okay? And there's an interesting anecdote about that, as a matter of fact, because the journalists who are following the stock exchange are not sure what that means, right? So the correspondent of the Times is asking what is the meaning? What do you mean when you say disorderly conduct as formerly in the stock exchange? And he says, they told me it's throwing away the hat, okay? And so he continues and he says, oh, throwing away the hat? That must be a compliment to the bears, right? So, I mean, it sort of gets you into the sort of very strange technologies that existed, again, only until 1801, because once they have the tribunal, the voluntary association, all those grassroots technologies, they absorb them. And you can tell with the speed with which they start making their rulings, announcing the rulings, that they basically consolidate a knowledge that was implicit and that they had cultivated and developed for a quarter of a century.
Thank you. I find this very inspiring. I also have two questions. One is, what's the relationship between the technologies to deal with bankruptcy which evolve here and older practices, for instance, where it's a matter of ordinary credit and the debtor is not able to pay up and goes bankrupt? That is also a story which evolves, had been evolving for a long time. And how are they related? That's the first question. The second is that you have associations with their own rules. That's not only in the stock exchange, but also in England, but that's everywhere, or in many places, that you have, for instance, associations of mountain farmers who have to protect themselves against avalanches. And so on the one hand, they are entrepreneurs, they are farmers. On the other hand, they have to cooperate and have to have their rules. Or you have the Chinese, and they are under a very special kind of government that many private associations evolve nonetheless, and they also have their rules. Now, how do you pursue or how do you see the relationship between those practices and later developments of democracy?
Okay. So first of all, sorry, because there were two questions, and the second can be very brief. The parallel is the New York Stock Exchange. So in fact, the New York Stock Exchange has a similar, in its foundation, it's a similar story. It's created as a voluntary association and developed that way. So this is where, as a result, you find, the closest kind of microstructure stories to what was happening there. But then, association instruments have been used to create stock exchange, and so they're kind of cousins of the British Common Law Voluntary Association. Apologies again. Regarding the two questions that you asked. So first of all, that's the part that's really interesting. I mean, I've been emphasizing the fact that they obviously the traders that operate in the stock exchange, they come from very many different cultural background. So I've mentioned the Jews. You have Quakers, who are another very important group. You have other religious minorities. You also have a lot of foreigners. As a result, and typically a lot of those people, they have in their family experience about like forms of law merchant, international trade, etc. So they have enormous roots that, so this is why it's very interesting, but also very difficult to establish a positive match of, this comes from that. Right, especially given that because a lot of those activities are illegal, there are very few records. So coming across something where they actually tell you we're doing this and this is where trace the whole genealogy is a very difficult endeavor. One thing though is that initially you can tell from the language they use, for instance, that one reference that they have is the English common law bankruptcy that I was referring to, so the so-called private bankruptcy, where, as I was mentioning, you put the assets of the defaulter in a trust, and then there's a number of procedures which are court enforced, and that enable you to sort out this thing. So in terms of the vocabulary they use, clearly they use the terms that are used in this body of law. But then the term starts meaning different things because, again, that instrument is not replicable because they cannot create a trust. Okay? Because, again, the trust would be carrying a financial instrument that would be vitiated from the fact that they come from an illegal contract. So as a result, I think that there's, in a context where people have a lot of ideas about how things have been done for centuries, as far as distress is concerned, there's also the production of a sort of homemade knowledge. And in particular, one thing, so I'm not really answering your question by looking back in time, but rather by looking forward. There's an interesting contribution that people from the stock exchange make during the 19th century as a leading proponent of bankruptcy reform. So as you know, aspects of the British bankruptcy were quite repressive. They kept, the prison for debts and these sort of things. And the level of the discharge and the speed of the discharge that were being made at the stock exchange, I think, convinced them of the merit of having a swift instrument. And so you see that especially in the 1840s, 1850s, when there's a lot of lobbying, parliamentary investigations and things like that, where they try to discuss those things, you find actually people from the stock exchange, sometimes even lawyers, who became lawyers when they retired from the stock exchange. So they were jobbers, then they moved to becoming judge in the stock exchange jurisdiction, and then they take a degree in law and they become very important corporate lawyers, right? And so they carry those ideas into the, on your second question, the fact that there are many other kind of orders and methods for associating, and it's absolutely true. And it's a very important point. The point I'm trying to make is inside the fact that nature finds its ways, and there are always techniques that enable people to organize themselves and sort out their problems, even sometimes without the law. There's something specific with voluntary association. Again, the first part of the story is basically how, without the law, they sorted out an instrument which was customary, okay? Still, the efficiency of the system when they are able to actually use a common law voluntary association is very significant, because suddenly they can rely on all the instruments that are available out there in common law. So I think what is really important here is, I think that you cannot tell the history of the development of the London city if you don't tell the story of voluntary association as a companion development.
Just one question, that is how, or did they at all incorporate different risk appetites in their assessment of defaulters?
Very good point. And actually, I wish the archive were more detailed, because I have some elements that I came across that exactly reflect that. So a short way to answer your question is actually to say that already in the market, in a stock market like that, you're going to have two types of operators. The pure stockbroker, okay, is just an agent who passes an order, okay? And you can do that, if you do it the right way, you can do that with zero risk. So you have to be careful, because if you start, just taking the client's order on credit, you're going to start building a position there, okay? But if you do that extremely prudently, you're going to be absolutely safe. And at the other end of the spectrum, you have the market maker. And the market maker has to use his own orders to match the position. And so there the risk is enormous, okay? So what you see, for instance, and that's part of the study of the book of a defaulter, is that there are cases where the committee tells you, okay, you can stay, but jobber no more. You cannot be a market maker. You stay, but until you've repaid the level of discharge we give you, you have to be a stockbroker, and we'll monitor you from time to time. We don't want you to start, making operation on credit or whatever with your client. You have to be boring. So in fact, the stock exchange is, with respect to that, is doing some kind of micromanagement at the individual level, either ex post when there's failure because they change you of category and they tell you now you don't do dangerous stuff, for instance, or preemptively. Sometimes you see their mentions where they post certain messages and they encourage a certain position to start being wound down, or and so they do all this kind of micromanagement of risk exposure. And again, the important element here is the discovery that you can make, because you have access as regulator, you have access at any time to the books of the operators.
Maybe one question from my side.
Yes.
More on the theoretical background. Would you say that this study, the formation of voluntary association, that is something that competitors create as rules and standards in the interest of all? Is that something that would also be comparable to the much older things that have been studied by Goethe and others, or the Magritte Trader Network, or the Champagne fairs that emerged as associations that were driven by market forces, somehow structured markets in that way? Is that on a theoretical level, would that be comparable?
So I have two answers. So I think it was the same question I was asked, in fact, earlier, but it's an important one. So I'm happy to take it yet and from another angle. So I think that really my message is that it's twofold. First, and that's a criticism that has been leveled against Graef, which is to what extent does he know that his corporation, his coalition of Magritte trader was truly informal and only sustained, right, by just incentives. Okay, so the dream of a purely economically designed organization. Okay, and I mean, this is something that he doesn't discuss, for instance, but that you can read all Graef, you will find no mention of this. Okay, but he has a discussion of the importance of what people call in the Graef model cheat the cheater. So basically, if someone doesn't cooperate, the coalition turns against them. Well, you need to understand the Magritte traders are Jews, and this is Talmudic law. Okay, so in other words, and this is something that has been, again, leveled as a criticism. I'm thinking of the work of Goldberg on the Magritte traders, for instance, where she basically says, careful, you have rabbinic and Islamic courts that actually are involved, and sometimes you have contracts that you think are informal because they're just a performance or a speech, but in fact they're formal because once you go in a court, okay? So I think that these are very important criticism to this Graef thing, and so you could think of that as a kind of post-Graefian, right, thing. And I don't want to go at least for at that stage so much into this versus that. But I think the very important point is that you have a problem here because if you have a formal instrument that you don't comprehend well as a historian, you're going to see something designed through the help of that instrument, producing results that you will ascribe to a system of incentives that exist independently of the formal system, right? Yet the formal system is out there, right? So in other words, just to repeat, the early stock exchange, okay, would be, so before 1801, would be perhaps something a bit more like Graef, okay? Except that there is the Trade Protection Society, except that there are also complications in the fact that because the operations are illegal, they also, they can be subject to fines, and that's a whole topic that we could add. And that fines, so it's not the same to have impossibility to contract, or if contracting exposes you to penalties. Because if this is so, then the incentives are designed kind of almost de facto, right, by the fact that you have a penalizing system, right? So the law may operate in reverse, by forbidding as opposed to helping. So what I'm trying to say is that there's really first a difficulty of sort of forgetting that there might be a legal framework because you may have an identification problem, and you may misread certain things. So for instance, buffeting, it's a very good example. Sociologists have been writing, there are a number of sociologists, for example, Alex Preda, he writes on the sociology of capital market, and he's very interested by buffeting, okay? And so he says, in early market, people are barbarian, but then they want to wear tie because that's the image that, those bankers, etc., they want to project, and so this is, and you're like, no. I mean, the buffeting does something. And this is actually, you have lots of quotes at the time where people describe that, and they say this buffeting and fun does something, right? And then they explain that it's actually an enforcement technology, which is informed by the legal system in reverse, because if you're confronting the guy and punching his face, he can take you to court. But you have to create this strange attack that prevents the victim from pressing charges, okay? And so the strange ritual, which you would think is anthropology, is in fact law, right? So, I mean, this is the part that I find fascinating in those stories, which is that there's a very severe identification problem that is there.
The mic is coming from above.
Thank you. Your response just prompted me to have this next question. Is what I find most interesting is where you ended, namely the separation between separation of the social from the economical.
Mm-hmm.
As you show in the presentation, also in London Stock Exchange, most of the contracts came with certain rituals, and sometimes even religious rituals. Right? So a lot of it had maybe not cultural, but symbolic value,
mm-hmm.
contractual symbolic value. And today, now, if we look at capital markets, the efficiency of the markets is something that most of us kind of are impressed by. Right? It depends on where you come from. If you're, like, say, from Western societies, and if you go to like older societies or different cultural societies, one of the things you will see is that maybe they still have these ritual bonds, ritual relations in economic relations, and then you'll say, oh, why are they so inefficient? This might be something you'll be proud of. But if you come from, say, outside of Western societies, and people come to Western society and say, well, how can you be so efficient and so profit-driven and meaningless in that instance?
which is basically the flip side of the argument, right? So my question is, where you ended with the presentation, what prompted societies like this to take away its ritual symbolic value and purely go to the efficiency of the argument?
Well, okay, there are many questions in this this question, and it actually enables me to, because I didn't really address the part that was the extension of the question of democracy, and I think it ties to that. So I'm going to try and wrap all that together. One thing that is really important in the process that's going to take place after is that there's going to be literally a war, okay, on the voluntary association format. I mean, that's one way to interpret what's going to happen in courts of justice later. And in part, it makes sense because if you think of those legal platforms, they are subaltern jurisdiction that can self-generate. So from a democratic point of view, or a governance, society governance, not the governance of the platform point of view, this is a tremendous power, right? And in terms of the French bourse, for instance, the French were never smart enough, or they were maybe too clever to enable an organization like that. So they wanted their stock exchange controlled, right? So what is remarkable in that development is that it's really, under common law, you had the means for a very hybrid creature, something that was social in its contour, but that could be deeply economic in its activity, right? And you cannot separate, right? It may be the same thing as the existence of ritual in trading, but maybe ritual is trading. So, I mean, on that part of your question, there would be many things to say. So the question I have is, why do we see over the 19th century under English law a kind of war against its own origin? And you see basically that triumphs with the effort, the act of the judicature, etc., in the 1870s, when they tried to rationalize the British legal system. And as they do that, all those kind of innovation, grassroots innovation, those that had survived, like the stock exchange, they let them continue to exist. But you cannot create new ones, okay? So what I'm trying to say here is that the eradication of the sociological element, right, or the cultural element, is in fact historically coincide with a political assertion of the authority of formal law that you try to stabilize. Okay, and for me that is really the question that is interesting. When, for instance, the members of the stock exchange, you saw that in the image, and I didn't have time to engage with that, but the lame duck here. The lame duck has a wig, okay? And so that probably means that he represents, in fact, a principal, so a client, and so the noble person had a terrible reputation in the stock exchange as, in fact, trying to draw cash from their stockbroker by not settling their losses, okay? And because they were so powerful and rich, the stockbroker didn't have the cash to make to make ends meet. And so when a lame duck who was a principal would do something like that, the market would be in trouble, okay? So this is why when you saw the regulation about the blackboard, one thing that they say is that you have to give the name of the guy who put you, so that we can visit that person and threaten that person too. And so the stock exchange people were thinking of themselves as, in fact, very advanced in terms of their democratic and their democratic conceptions, right? So you have description of the 1801 event as a political event and as a form of triumph of democracy. So the stockbroker thinks of, the English stockbroker at that point thinks of themselves as proposing a deeply democratic society, because after all, voluntary society is an expression, right, of sovereignty. So that's exactly an expression of democratic sovereignty. And the fact that there's no contradiction in their mind between their local project and the global project is almost natural, right? Because they promote democracy locally, and that's just part of the law of the land, which gives the right to contract. And it's by using the right to contract that we could design that institution. Under the founding stone of the new stock exchange that they built just after that, they have this sentence which reads that this establishment is protected by the principles of the English Constitution. So they don't see themselves at all as people who evade rules. Huh? So getting back to your question, what I think is at the heart of that is, in fact, an enormous political power that exists in this legal devolution of the platform. And I think it's a parallel that's very relevant with today, right? I mean, if you think of the, I mean, I don't know, the Facebook okay, Facebook with Libra, not okay, right? And that's exactly when the social network crosses the line and becomes an economic organization, right? So I think it's a question of where is polity, right? And depending on how you answer that question, you pick the society you have. What I find fascinating is that, well, where is that question played out in the London Stock Exchange? And what is the London Stock Exchange if it's not like the initial piece of DNA of modern capitalism?